Are you appearing in the Jalpaiguri matter? Yes.
Your Lordship, I've given notice, Your Lordship. Notice has been given, Your Lordship. It was sent by WhatsApp because
I can't understand what you said.
the notice was sent by WhatsApp, Your Lordship, because the advocate for the other side had said so. It's there, the notice I have given.
Yes, you're there, Mr. Borman.
Lordship, we have already, Lordship, in item number 1, we have already filed the report in sealed cover as per last order dated 12th May 2023. Report of superintendent.
Who are you appearing for?
For state.
For the state?
Lordship.
Sealed cover over here. Why is it in sealed cover?
It was so directed report of the superintendent North Bengal Medical College regarding the condition of the mother and the fetus.
Your Lordship, the
Condition of the mother.
This case, they are praying for termination of pregnancy. Yes, Lord.
16-year-old rape victim. Your Lordship, a 16-year-old rape victim girl. She's her mother sought for medical termination of her pregnancy. By this writ petition, were made representation.
What is the duration?
8 months.
8 months.
8 months.
That is way beyond the act.
But because that is why the special permission was sought. In the Act, Your Lordship, there is a provision where if
how can I say
there
yes?
is a risk, there is a risk involved. She suffers from, Your Lord, the child, if given birth to, will have a neurological disorder, and she's
forget about the child. What about the health of the mother?
That is why, Your Lordship, the direction was given whether the board to decide whether it is possible or not.
Not possible at 8 months to say yes.
The board has given its opinion, Your Lordship. It is possible if a rape victim is allowed to.
Show me the act.
Your Lordship, the Act, section 3, Your Lordship. And he looks, Your Lordship.
এটা কি না না করছো কেন আগে দেখো What does the Act say?
The Act says that if it is after 12 weeks, it is not possible. But if there is any medical reason for which it is required, it can be. There is a medical.
12 weeks and 8 months.
Yes, Your Lordship.
Do you realize the difference?
Yes, Your
The
Lordship.
mother may die.
That is if she's allowed to give.
So you want to
if she's allowed.
Please, who is the petitioner before the court?
The mother of the victim.
Then the mother does not care whether her daughter dies in the process.
That is why, Your Lordship, the board has given its opinion that it will be more risky.
The board says that it may even lead to maternal death. That is the report of the board.
Then Your Lordship kindly decides according to the report of the board.
How old is the girl?
She's 17 years old, Your Lordship. She's a rape victim. That is the thing.
Please mute yourself.
Lordship.
Which section is this?
Section 3, Your Lordship. Your Lordship, subsection 2, clause I, 1 and 2, Your Lordship. B, 1 and 2.
Please. 5 months outside window, and here it is 8 months.
Yes, Your Lordship.
When did you file the writ petition?
Writ petition was filed in May 4 this month, Your Lordship.
This month. So why did you wait for 8 months?
Your Lordship, I have no instructions regarding that. I was instructed by the advocate who is appearing before the learned Jalpaiguri circuit.
There is absolutely no reason for you to wait for your daughter to become 8 months pregnant and then file a writ petition. And now you want an order before the vacation.
Your Lordship, because after 9 months, the report.
And why are you not before the Jalpaiguri bench?
Because
Why did you
it's
not
a-
go before the Jalpaiguri bench?
It was moved before the Jalpaiguri bench. The order was given on May 12, Your Lordship. Thereafter, because after 9 months, so she will anyways will have to give birth. That is why it was urgent. That was I mentioned.
Naturally.
Yes, that is the.
Then why did you wait for 8 months?
I understand, Your Lordship, but they had this. She's a rape victim.
And who will take responsibility if the petitioner's daughter dies? Who will take responsibility? And the court will say, yes, go ahead and medically terminate her
Lordship,
pregnancy.
Your Lordship kindly decides according to the opinion of the board. Whatever Your Lordship takes this decision.
Yes, what does the board have to say? Mr. Borman?
Lordship, the report is, there is a danger of the mother also, the report says. And already 34 weeks, 3 days on the date of the board's report.
She was how many weeks pregnant on the date of filing of the writ petition?
31 weeks, 5 days.
31 weeks.
5 days.
Which paragraph in the writ petition says that the mother does not, the petitioner does not want her daughter to have the child?
Paragraph 4, Your Lord. She is now 30 weeks plus pregnant. Paragraph 4, and Your Lordship.
She was 30 weeks pregnant on the day of filing of the writ petition. What did she say? She was, this happened, the incident happened on the date of the funeral. Whose funeral?
Father's funeral.
Whose father?
Her father's funeral.
The petitioner's,
Husband's.
the petitioner's husband's funeral.
Husband's.
The daughter was,
Yes, Your Lordship.
and who is this Bobby Tamang?
He's the accused person.
I know he's the accused person.
But his relationship, Your Lordship, with the, I have no idea regarding that.
Who will take the, who will give the guarantee, Mr. Or the undertaking, Mr. Borman? If anything happens to the petitioner's daughter?
Since the daughter is minor still now, less than 17 years, mother has to take the, because she is the petitioner.
And the Jalpaiguri circuit bench did not just said that you file a report.
Yes, Your Lordship. May 12 order, Your Lordship, kindly looks.
They have moved on the last date.
You wanted matching of the DNA.
Your Lordship, with regards to whether the body tamang is the that was directed. I did not seek that such prayer. It was directed by the court, Your Lordship. If it can be preserved for the criminal investigation.
You have to give a consent in writing.
Yes, Your Lordship.
Have you given that? Is it before the court or not?
Your Lordship, consent and this is not before the court. As per the last annexure, Your Lordship, there by the advocate, a representation was made and subsequent representation.
You, the mother, will have to give a
Yes.
consent in writing. What advocate?
That had Your Lordship had each Your Lordship had sought permission for page 16. At page 16, Your
The
Lordship.
petitioner claims to be the widowed mother of a minor victim girl aged 16 years who was raped by the accused person on the day of the petitioner's on the day of the funeral of the petitioner's husband. That is the father of the minor victim girl. Stop. The petitioner 16 or 17 crore. The petitioner seeks medical termination of pregnancy of her daughter. Stop. The petitioner's daughter is presently is 8 months pregnant at present. Stop. The petitioner's daughter was 31 plus weeks pregnant, 30 weeks plus pregnant at the time of filing of the writ petition on 3rd May 2023. Stop. Next paragraph. The matter was moved before the circuit bench at Jalpaiguri, and by an order dated 12/5/2023, a coordinate bench directed the superintendent, North Bengal Medical College and Hospital, Shiliguri,
Yes, Your Lordship.
Shiliguri, to form a medical board for the clinical examination of the petitioner's daughter and the fetus, and to file a report and to submit a report. Stop. The medical board was also directed to give their opinion as to whether the fetus can be preserved for matching of the DNA for evidence in a case under in a case now if the petitioner sought to initiate any case under the POXO Act, which year is it? 2012.
2023 POXO Act 2012.
2012. Stop. Next, the respondent Department of Health and Family Welfare, and the Chief Medical Officer, CMOH is represented. Stop. Learned Counsel files the report of the medical board in a sealed cover. Stop. The report is dated, the medical report is dated 15/5/2023. Stop. And states that although termination of the advanced stage of pregnancy states that termination of the advanced stage of pregnancy may invite minor to serious complications to the mother, including maternal death. Stop. The petitioner's daughter was found, the psychiatric mental state of the petitioner's daughter is also part of the report. Stop. The court does not wish to reproduce or state the contents of the report as to the victim girl's mental condition in the order. In this order. The report, however, concludes that the consensus of the medical board is that the pregnancy can be terminated as per the existing MTP Act. Stop. Next. Section 3 of the Medical Termination of Pregnancy Act, 1971 provides for termination of pregnancies by registered medical practitioners. Stop. Section 3 within bracket 4 within brackets 2. Section 3 within brackets 2 provides that a pregnancy may be terminated by a registered medical practitioner where the length of the pregnancy does not exceed 12 weeks, or where the length exceeds 12 weeks but does not exceed 20 weeks. If not less than 2 registered medical practitioners are of the opinion, formed in good faith, that the continuation of the pregnancy would involve a risk to the life of the pregnant woman or grave injury to her physical or mental health, or there is a substantial risk that the child, if born, would suffer serious physical or mental abnormalities as to be seriously handicapped. Stop. The medical report of the board states by consensus that the pregnancy may be terminated, but that such termination may invite minor to serious complications to the mother, including maternal death. Stop. Section 2, within brackets, choto b, within brackets, choto I, is the first, provides that provides that a pregnancy which exceeds 12 weeks, which does not exceed 20 weeks, may be terminated by not less than 2 registered medical practitioners, provided the continuation of the pregnancy, provided the 2 medical practitioners, provided the 2 or more medical practitioners opine in good faith that the pregnancy would involve a risk to the life of the pregnant woman or of grave injury to her physical or mental health. Stop. Explanation I provides that where the pregnancy is alleged by the pregnant woman to have been caused by rape, the anguish caused by such pregnancy shall be presumed to constitute a grave injury to the mental health of the pregnant woman. Stop. Section 3, within brackets 3 of the Act, further provides that in determining whether the continuance of a pregnancy would involve risk of injury to the health under subsection 2, account may be taken of the pregnant woman's actual or reasonable foreseeable environment. Actual or reasonably foreseeable environment. Stop. All that follows next, all the subsections which follow, all the subsections and explanations which follow section 3 within brackets 2 within brackets choto b are on the premise of the pregnancy not exceeding 20 weeks. Stop. In the present case, comma, the petitioner's daughter was already 30 plus weeks pregnant at the time of filing of the writ petition. Stop. It is inconceivable that the petitioner, comma, knowing fully well that her daughter was a victim of rape, and that too "30 weeks before filing of the writ petition, comma, would wait for her daughter to reach an advanced stage of pregnancy before approaching the court." Stop. This has not only resulted in increasing the risk of her daughter's physical and mental health in the interregnum, but also in the event of termination of her daughter's pregnancy. Stop. The main contention of the primary contention of the petitioner is that the pregnancy should be terminated since the pregnancy was unwanted and is a result of a rape committed on her daughter. Stop. Explanation I to section 3 within brackets 2 within brackets choto b supplements the grave injury to the mental health of the pregnant woman being one of the circumstances where a pregnancy within 20 weeks may be terminated. Stop. The supplemental reason is where the pregnant woman, where the pregnancy has been caused by rape. Stop. Although this appears to be the main consideration of the present case, as also the victim girl being a minor at the time of the offense, on the date of the offense. Stop. Next. Although the mandate of the act is clear that a pregnancy cannot be terminated which after 20 weeks, comma, this court is of the view that termination of pregnancy, comma, for women who are who have attained the age of majority, and for those who are minors, comma, should be a matter of choice. Stop. The importance of having and exercising that choice is all the more relevant where the pregnancy was unwanted or a result of a forced non-consensual act. Stop. A woman cannot be burdened with a child. A woman cannot be deprived of the right to choose whether the woman wants to have a child or not. Stop. The right of choice, the right to choose, would also include the awareness of the health risks which would accompany the termination of pregnancy. Stop. It would, if a woman chooses to terminate her pregnancy, comma, it should be assumed that the woman has also exercised that choice, the choice to suffer the consequences of termination of pregnancy to her physical and mental well-being. Stop. The NTP Act is of 1971. And the law with regard to the rights of a woman to her self-determination has also developed in the meantime. Stop. Next, in the facts of the present case, comma, the petitioner's daughter is a victim of rape. Stop. The medical report reflects the mental condition of the petitioner's daughter brought about by the act of rape. Stop. Without going into the details, comma, the report states that the petitioner's daughter is suffering from mental distress caused by the act of rape and sexual abuse. Stop. The report of the medical board, this and the consensus of the medical board strengthens the hand of the court to permit the termination of pregnancy of the petitioner's daughter. Stop. Needless to say, the court has been made aware, by the report, by the contents of the report, that the termination at such an advanced state of pregnancy may result in severe consequences to the petitioner's daughter. Stop. The larger ramifications and consequences if the termination is not permitted would, may, however, endanger the mental agony of the petitioner's daughter, so as to constitute a grave injury to the mental health of the pregnant woman under explanation I of section 3 within brackets 2 within brackets choto b of the Act. Stop. Next, the petitioner, as the mother of the minor girl who is to undergo the procedure for termination of pregnancy, shall give a letter of consent shall give an undertaking to the shall give her consent in writing as the guardian of the minor child, of the minor girl, to the termination of pregnancy. Stop. The letter of consent should be given. This is a requirement under the Act. Stop. The letter of consent should also state that the concerned hospital or the medical practitioners who undertake the termination of pregnancy shall not be held responsible for any risk to her daughters, to the girl, to the victim, to the minor girl's health or life. Stop. The consent of the of the minor girl shall also be taken by the concerned hospital before the termination of pregnancy, before the pregnancy is terminated. Stop. Next, WPA 1140 of 2023 is accordingly is disposed of in terms of the above. Stop. It is needless to say, the petitioner shall take expeditious steps to act in accordance with this order to prevent any further risk to her daughter's physical or mental health and well-being. Stop.
Your Lordship, urgent certified copy because the server is not working, Your Lordship, for server copy.
Urgent certified copy.